apologize, Commissioners. Once again, I thank you for everything you do. I'm here again requesting that the minutes of May 10th, 2011 have these additions made to it as I was told I had to do.
Did we approve those? No.
Yes, you did.
We did.
And so you said I had to submit this.
Yes, and we'll put it in the file along with those records. Absolutely, unequivocally, no problem. Can I take a look? Okay, next.
I'll have to do the same thing with this evening's minutes.
The response is going to be the same, Mark.
No, I understand. But I wanted to state that what we said is Mr. McNally informed the Commission of a new group, We the People of Connecticut, which consists of a group of lawyers who will be watching for violations of the Constitution. Chairman Overton stated that the people who originally put the language in the Woodbury zoning regulation were the people of Woodbury, elected by the people of Woodbury, and that he believes those people had a good reason to put the language in the regulations. I added that they may have had a good reason, and it may have been for years. However, the point that we're trying to make here is that they are on the rule as presently in the Commission's regulations is unconstitutional.
In your opinion?
In my opinion.
Have you ever had a legal opinion on that matter?
Yes.
Can we have it?
I provided it to you.
A legal opinion? No, from your lawyer.
No, not from my lawyer. But I provided you with the court cases about freedom of speech and signs.
That may be valuable, and it may help the Commission in its deliberations. You made a statement, and you and I disagree, which is healthy, right, for discussion. I do not believe that our regulations violate the Constitution. If you believe they do, you need an attorney to tell us how they violate the U.S. Constitution. Please do that. Just saying that over in Mansfield there was a problem, and over in this town there was a problem, that does not say that this book, nobody else's book, this book, violates the Constitution. You've not done that.
That's the first.
I invite you to do that.
Okay, you're inviting me for the first time to do that because back in November, I did have a lawyer here who could have come up and appeared.
I would have preferred him to have written it out so that we could review it.
All I'm saying is I will pursue that after.
Please.
Okay? And so I will make also an arrangement to just put it in. It's my opinion.
Absolutely.
That's where I'm coming from.
Yep.
I feel I have.
We will take that and file it with the minutes. Absolutely.
Now, at the last meeting, you stated that there was an opinion of the lawyers as to the regulations.
Yep.
Has that come back?
I believe it came back, and no one has directed staff to distribute it to anybody yet. It hasn't been. I haven't seen it. When did it come in? You were away until
I recall
today.
it was in.
No, this was the second one.
I know. The second report.
Yep.
Okay. And that has not come in.
The second one has come in.
It has come in.
And your question is?
Okay, and it hasn't been distributed.
Nope.
And she can't recall when it came in because that was over a couple of weeks ago.
Right. Catherine was away on vacation for a few days, and she and I touched base at 4 o'clock this afternoon, or 2 o'clock this afternoon. And I do not know what the exact content of the letter is, but I know the gist of it is that we have a set of defensible regulations.
And when will
Which is why I want your legal opinion that we don't.
When will that be available?
Next meeting.
Because what I'm trying to do is see
The point is that the communications between attorney and client are going to remain privileged, period. You don't get to see it ever. Ever on.
I do.
No, you don't.
It becomes public record.
No. It never becomes public record.
Don't say you can't.
Well, you heard it here. It never becomes public record. Attorney-client privilege is exactly that. It's like doctor privilege, psychologist privilege, priest privilege. You don't get to see it ever.
Regulation is proposed to be.
Have this argument, my lawyer versus your lawyer, if you like. But I believe, and I have a lawyer who's advised me to believe, that these are not in violation of the Constitution.
And you haven't reviewed it, but you say that that's the opinion.
Right.
You say you
I haven't read the letter.
You haven't read the letter. So right now, that's your opinion.
No, that's my understanding of what my lawyer said.
Okay. So it appears there are two things that are going to happen. If I will get my lawyer
Please.
to provide an opinion, and it's based on
The
the old regulations. Okay?
Meaning
Substance.
what?
Meaning
Or if it's not the 2010 version, it's not going to mean anything?
one or more signs, total aggregate amount of signage for property not to exceed 12 feet.
I understand, you're right, that's what you said. These regulations are May 2010, so these are current regulations, not old regulations.
And when were they passed?
May the 1st, 2010.
And it's in there.
Yeah,
This or the revisions.
doesn't matter, there's only one set of regulations in enforcement at any one day and time.
And you passed these regulations May the 10th.
The revisions,
You
yes.
just had the review.
That was
Okay?
the latest
You did
revision.
not have a hearing on these regulations.
Yes,
which
absolutely, absolutely. We went through the
2010.
process. All right, this is not the time,
2010.
this is not the time
Oh, I'm sorry.
to argue the process.
So that's this regulation.
If you believe
So
we
that's-
screwed up, just tell us and we'll go look.
What I'm trying to understand
Yep.
also. So the 2010 is this regulation?
Yep.
It's not the one which has been revised. You sent to the lawyers for review.
That doesn't exist yet.
Okay.
The one that you haven't seen.
Right.
That one?
There will be a public hearing on that?
Yes, there will be a compendium of changes. This is why this is taking longer than normal. There are Aquifer Protection District changes. There are statutory updates that are required because of the last session and the session before. So there's a compendium of stuff, not just signs. Signs is one, yes.
And that can't be made public. So that I can have
The
my
opinion that was,
lawyer review it.
the opinion,
To see if it informs.
that's,
Because
you see, the point is, I'm trying to explain to you where you just mischaracterize what's going on here. We're not hiding a regulation. We're hiring a legal opinion on whether it's constitutional or not. That's a legal opinion which is attorney-client privilege. The draft, as I warned you at length 2 meetings ago, doesn't exist. It was sent to this commission for its review, and it will not be published until we are satisfied that we want to publish it.
So what you're saying is, your lawyers came back and said that original thing, which I requested to be changed, was constitutional.
Yes, and we talked about this. There is a possibility that there would be an interpretation that implied that there was, what's the word I'm looking for? Discrimination among uses. And we drafted language to avoid the potential, the possibility of that interpretation. We had a legal opinion on that, right? We're going to review that legal opinion in due course.
Well, you made, which I feel, and I can get their assistance, to be unconstitutional.
See, under exactly what you've said, I'm going to be on your side of the table. If it's unconstitutional, I don't want part of it. I just don't believe it is.
See, Martin, you're jumping around the issue. The original letters, which the lawyers
Yes.
came back, which I have a copy of.
That attorney-client privilege that you have a copy of?
Yeah.
Okay.
From back in November.
You get that, Jamie?
From back in November. Back in November.
Okay.
You provided it to me.
No.
Oh, yes, the commission provided it. I went on. I'm
The
sorry.
second one never went out.
I'm not talking about the updated regulations.
Okay.
I'm talking about the original two.
With the potential for the
Yes.
discrimination. Yes, because you guys wanted to know about it. But the draft regulation...
Right, and I didn't say I was.
Okay, sorry.
Okay?
Yep.
You got that, Jamie? I mean, you are really trying to put yourself out in the public as a defendant of something which potentially could be unconstitutional.
And I will not do that if it's shown to me that it is unconstitutional. I'm gone that day and I'm on your side of the table.